First, in the kind of pet ordinance discussion, there were kind of four different alternatives brought forward for what exotic pets can be allowed and what can't be allowed in the city. Can you kind of briefly describe the differences between those four?
Sure. So where we started, which known as Alternative 1 was the original draft, that one had pretty much a wholesale ban on things like constrictor snakes of any size, sugar gliders, things that were rather upsetting to the Herpetological Society. And so then we came along with version 2, and version 2 allowed sugar gliders back, but it still had some prohibitions on things that people commonly keep. And so we kind of expected we would have that discussion with them. And so at our meeting in March, we brought them in and we had some great dialogue with pet owners who own, reptiles and amphibious things. And so we got some great insight from them, and we went back to the drawing board. And after a little research, we came along with version 3 and version 4. And so version 3 and 4 are largely the same. It's just that version 4, which is the one we're selecting and moving forward at least next month for final action, allows for a permit that a person can buy if they want a larger constrictor snake than 10 feet. So sugar gliders are back in. Many of the reptiles that people were opposed to being banned are also back in. Rear fang snakes back in, under 10 feet. And if they have snakes that exceed 10 feet, or prohibited animals that would exceed 10 feet, they can apply for a permit for that, whereby there's a little different inspection requirement. They'd have to dialogue with the humane officer and show that the animal is properly kept and properly contained to keep the public safe and to keep their neighbors safe and things. So where we're ending up is pretty far off from where we began. We began with a very restrictive ordinance, and I think that when people came in to comment about it, they thought that it was too restrictive and that it was way too intrusive. And where we're at now is we've opened up that ordinance to allow back in a lot of those things that people were worried about having banned, but we've also found a responsible way to allow a little larger one if someone has it and they've got the training and the means to keep it. Then there's certainly no need for them to have to either move or rehome that animal. We can work with them, but we work with them on a case-by-case basis. And so the process they would go through is really no different than what we do with pet fanciers and urban chicken permits and things like that. Where beekeeping, we have processes for a lot of those things that we didn't have 10 years ago, but they're good processes and they're not in demand in such high volume that they present a body of work that our humane officer and the clerk can't keep up with it. They can keep up with it just fine. So I think we're ending up in a much better place than where we started from, which is the exact reason we wanted to have a dialogue with people and not decide on day one that we wanted to just adopt version 1, because we would be in a very negative place, I think, if we had. So we've come to a much better work product by waiting a little bit, and so that's kind of where we're ending up now.
And what are the changes that the committee wants to see before they approve kind of this fourth version?
Well, they wanted to approve there's one thing that they took out of Alternative 4, and that was a provision that would require permission or notice to the abutting neighbors. I think that invites neighborhood conflict is one of our concerns, and our other permits don't provide for that. So we took that out. We have re-added the rear-fanged snakes back into the acceptable items because when the Herpetological Society came to educate us about those items, yes, they're venomous, but the venom that they secrete is damaging to their own prey, not to humans. They don't pose a defined human threat, not like one might think. And so I think just having a better understanding of the creatures themselves and what the real hazard is helped us narrow down the list. And a lot of the other things that were on the list to start with, people weren't real concerned about. And so I think the things they were concerned about, though, we found a reasonable way to deal with. So.
And do you expect there to be much discussion on this at the next meeting in May?
I don't think so. I think that we'll have all of those revisions put in. We'll just give a quick check of our final product, make sure that it encompasses all the things that we asked for, and if it's acceptable, we'll send it forward to the council for final approval.
And between the last time this was discussed in this meeting, did you get any more public feedback?
Much less this time than we did in March. I think when we had the original ordinance that we considered in February and March, the first meeting had nobody in attendance, and we decided to wait because we didn't have time to network with people who were actually affected. March, we had massive turnout. We did not discuss it. We didn't discuss it for a final decision because we just needed that time to gather some additional provisions and create some alternatives. But we've come a long way from where we were. And so, this time, I think that the assistant city attorney did a fantastic job of networking with the people who came to the meeting and really revealed themselves to be sources of information and insight where we needed to know, more about the animals in the first place. And so they were very helpful to her. And the Herpetological Society from UWSP, their group that attended the meeting was very gracious, and they were very helpful in creating the ordinance and trying to refine the list for us.
So that's all the questions I have about the kind of animal ordinance stuff.
Okay.
I was just a little curious about the rental inspection thing that was brought up tonight. What exactly is this planned for?
Well, rental inspections will allow us to form a zone where we would designate that we've got first a high density of rental units and then contributing blight as a result. And then once that zone would be approved, then the inspections department would be able to inspect inside and outside rental units and on a cyclical basis. And so we did not make a final decision tonight. It was on for discussion only. In 2013, we created our original rental unit licensing program, and it wasn't wildly popular among landlords, but it was highly effective. And it found, and those inspections, like Bill Hebert said tonight, they inspected almost 1,000 rental units. And some of the stuff they found is pretty shocking. And so that program compelled those things to be corrected. And so in a lot of situations where tenants are living with things that are either unacceptable or dangerous, and they're afraid, they just don't want to take a stand and have that voice because they're afraid to either be, evicted or whatever. I think sometimes people are afraid to speak up, and the condition persists. And so often when you do an exterior only inspection, there are some rentals where they'll slap vinyl siding on the outside, and the outside of the house looks okay when you drive by, and the inside is in complete decay. And so there's things that are just unsafe and unsanitary in a home that people shouldn't have to live with. And so I think that by finding a middle of the road, our rental licensing plan, we suspended enforcement on that because we were trying to find a new plan that would comply with the state law changes. We believe this new plan will comply with that. And as one zone begins to be remediated, we can designate new and different zones. This time around, if the plan passes, they were through the center zone pretty firmly with that 1,000-unit inspection that they were doing with the rental licensing program. So they wouldn't start there again. They would pick another area and work through that. And when they've worked through that, perhaps designate, maybe a third one, and just take the city in segments and work it through that way.
And is there any sort of feedback that the city would like from maybe landlords or people in rentals to kind of craft this new plan?
First, I think the message going forward is that landlords who are doing it right, who are, repairing things that need to be repaired and are keeping their units in a decent, safe, and sanitary condition, they have nothing to fear from any of this. They had nothing to fear from licensing because they would have passed inspection easily. Those, though, who don't fix things and are reticent to do maintenance and allow their tenants to live in substandard conditions and then make money off that, that's where there's going to be a problem, and that's also where there's some wild opposition to things like this, and it's often positioned as big government and overreach and everything else, but at the end of the day, people living in substandard conditions while someone else makes a profit from that is just a bad arrangement. And so, if we can find a way to inspect rental units on a fair playing field and make sure that we are getting conditions corrected that need corrected, and make sure that our new plan dovetails with the state law that was passed down in Madison, I think that's a positive moving forward. It's certainly a positive for tenants, and it's not about how the tenant keeps their apartment. It's not about how the tenant lives and what kind of housekeeper they are. It's about what they're forced to endure as a tenant in the house that they pay to live in. And when things are substandard and just sometimes even dangerous, WASA does have a rent abatement ordinance that's highly functional. The tenants can right now apply for rent abatement if they have conditions in their home that qualify. But that said, there's a lot of tenants who are afraid of retribution, and they're just afraid that they're going to have to go through a circuit court process if they get evicted for using that voice and speaking up. And so if something is found on a routine cyclical inspection, that's not the tenant's fault. And so sometimes you can get at those issues without that tenant having to be the lightning rod that causes the enforcement. So, I think it's a positive. I don't expect that it will be loved by landlords. The last one wasn't. But I think if we can do it legally, I think we should.
And then when do you expect to see the plan come back to the committee?
We asked for it for June, for our June meeting, and that gives us some time to network with neighborhood groups and to talk with, our constituents as well and get some of that public feedback. And so hopefully by the third Monday of June, we'll at least have a product we can review. and maybe move it forward from there. I wouldn't see it starting before July, because once the committee approves it, it still has to go through council. So I think logistically, late summer, but we're off to a good start.
Okay. Anything else you'd like to add?
No, I think we're good.